The Kentucky Supreme Court has refused to enforce an arbitration agreement again, possibly bringing them to loggerheads with the United States Supreme Court. Back in 2017, the Supreme Court slapped them down 7-1 in Kindred Nursing Centers against Clark, and now we have North Kentucky Area Development District against Snyder. So an employee and employer sign an arbitration agreement, but the Kentucky court will not enforce the agreement. Why? Well, there's a statute in Kentucky prohibits employers from conditioning employment on an agreement to waive or arbitrate any existing or future claim. So, the Kentucky court makes two major points. One, that statute makes the action of the employer ultra vires and therefore void. So void, you can't enforce the arbitration agreement. Second point, the statute in Kentucky is not preempted by the Federal Arbitration Act because the statute does not discriminate against arbitration. It doesn't single out arbitration agreements. It just prevents employers from conditioning employment on arbitration. So they're saying it's not an anti-arbitration clause provision, it's an anti-employment discrimination provision. I'm sorry, friends, it's wrong. On the face of the statute, it singles out arbitration, clearly preempted by the Federal Arbitration Act. Perhaps we'll see this case go to the U.S. Supreme Court. So, until next week, keep on doing good work.